In January 2025, former President Donald Trump, during his second term in office, signed an executive order aimed at ending what is known as birthright citizenship in the United States. This policy stirred up major national debate, as it directly challenged a principle that has been part of American law for over a century. Birthright citizenship refers to the rule that anyone born on U.S. soil automatically becomes a U.S. citizen, regardless of the legal status of their parents. This idea is rooted in the 14th Amendment of the U.S. Constitution, which was adopted after the Civil War. It states that all persons born or naturalized in the United States and subject to its jurisdiction are citizens of the United States and the state where they reside. For decades, this law has been interpreted to mean that even children born to undocumented immigrants or people visiting the country temporarily would be granted automatic citizenship. Trump, however, argued that this interpretation was flawed. He claimed that the phrase, "subject to the jurisdiction thereof," in the 14th Amendment was being misunderstood. In his view, people who are in the country illegally or on temporary visas are not truly under U.S. jurisdiction in the way the amendment intended. As such, their children, even if born in the U.S., should not automatically be granted citizenship. This executive order, signed on January 20th, 2025, the very day of his inauguration, stated that children born in the United States would only be recognized as citizens if at least one of their parents was either a U.S. citizen or a lawful permanent resident. The order also added that this change would only apply to children born after February 19, 2025, giving a 30-day window for implementation. Trump said this move was necessary to protect the integrity of American citizenship and to discourage illegal immigration. He argued that the current system encouraged what he called birth tourism and the use of loopholes by immigrants hoping to secure benefits for their children. Not surprisingly, the order triggered immediate backlash. Several states and civil rights organizations filed lawsuits almost instantly. Legal experts and immigrant advocacy groups called the move unconstitutional. They pointed out that the Supreme Court had already settled the issue back in 1898 with a case known as United States v. Wong Kim Ark, where the court ruled that the children of immigrants born on American soil were indeed U.S. citizens, regardless of their parents' immigration status. One of the first legal challenges came from the state of Washington, which led a coalition of other states including Oregon, Illinois, and California. A federal judge quickly issued a temporary restraining order, blocking the executive order from going into effect, at least for the time being. Other lawsuits followed in states like New Hampshire, Maine, and Massachusetts, some led by the American Civil Liberties Union, ACLU, and other immigrant rights groups. Their argument was simple: the Constitution can't be rewritten by executive order. Any change to the 14th Amendment would require a constitutional amendment or a major Supreme Court ruling. Trump's legal team fired back, saying that past interpretations of the amendment were too broad and did not reflect the original intent of the law. They emphasized that this new policy was focused on restoring what they called the true meaning of American citizenship. While legal scholars debated both sides of the issue, the real confusion began when different courts started making different rulings in different parts of the country. Some judges issued nationwide injunctions, blocking the order entirely. Others limited their rulings to their specific jurisdictions. The matter escalated to the U.S. Supreme Court. But instead of ruling directly on whether Trump's executive order was constitutional, the court focused on a different question: whether lower courts have the power to block a federal policy nationwide, especially when only a few plaintiffs were involved. In a 6-3 decision handed down in June 2025, the court ruled that lower courts should not automatically issue nationwide injunctions. They should limit their rulings to the specific plaintiffs or areas directly involved in the case. This decision was seen as a procedural victory for Trump, even though it didn't settle the bigger question of whether the order itself was legal. As a result of the Supreme Court's ruling, Trump's policy was still blocked in states where lawsuits had succeeded, but it was not blocked everywhere. This created a messy legal situation. A baby born in California might still be eligible for citizenship under the old rule, while a baby born in another state, where no injunction existed, might not. The legal patchwork forced the Department of Homeland Security and other agencies to delay implementing any widespread changes while they waited for more clarity. Many legal experts and immigrant advocates warned that this situation could lead to chaos and deep legal uncertainty. Hospitals, immigration offices, and even public schools would face tough questions. Would they be able to determine who is a citizen and who isn't, especially if the rules varied from state to state? Some feared that stateless children, born in the U.S. but denied any nationality, could become a new and vulnerable group in society. In response to the Supreme Court's decision, advocacy groups began organizing new lawsuits as class actions, hoping to cover broader groups of people and achieve broader legal protections. Meanwhile, the Trump administration continued to defend the policy, saying it was time to take a stand against what they saw as abuses of the immigration system. Trump also doubled down publicly, saying in speeches and interviews that no other country gives away citizenship as freely as the U.S., and that change was long overdue. Opponents countered that the U.S. actually shares birthright citizenship with several other countries in the Western Hemisphere, including Canada and Mexico. They also argued that stripping citizenship from U.S.-born children would do more harm than good, potentially creating a permanent underclass of people with no legal status, despite being born and raised in America. Many viewed the move as political theater, an effort to rally support from Trump's base by focusing on a hot-button immigration issue during a highly charged election cycle. As of mid-2025, the legal battles continue. Lower courts are still hearing arguments, and it's likely that the issue will return to the Supreme Court again, this time with a focus on the constitutionality of the executive order itself. Until then, birthright citizenship remains mostly in place, but its future is uncertain. The situation has exposed deep divisions in how Americans view immigration, the Constitution, and what it means to be a citizen.